Hi, good morning everyone. Welcome to Mohan's Teaching Corner. Today we are going to discuss about the constitutional law, understanding the foundation of Indian democracy. So if you are new viewer of this my channel, please do subscribe and share, like. Okay. So introduction to constitutional law 2. So welcome to our journey through operational aspects of Indian constitution. This course built on constitutional law by examining how various organs of government actually functions. So we are going to explore three pillars of Indian democracy, that is legislature, executive and judiciary, along with their interaction through federal structure. So this knowledge is very important to understand how constitutional principles translate into real governance and justice delivered in India. So here legislature under the Indian Constitution. So the legislature is a lawmaking body in Indian democratic system. Our constitution establishes the legislature in two levels. One is union legislature, that is parliament. Okay, then state legislature, that is in state level. So union legislature, parliament divide into in two ways. One is bicameral structure consisting of Lok Sabha and Rajya Sabha. So Lok Sabha called as House of the People and Rajya Sabha called as Council of States. In state legislature, it can be unicameral, that is only legislative assembly is there, or bicameral, that is assembly plus legislative council. In assembly, MLCs, MLLs will be there, and in a legislative council there is a MLCs are there. So let us discuss our parliament. It consists of Lok Sabha and Rajya Sabha. So Lok Sabha considered as lower house and Rajya Sabha is the upper house. So in Lok Sabha, direct elections in every 5 years, maximum 552 members are there, and 530 from states and 20 from urban territories, and 2 Anglo-Indian nominees. Currently, it has the number 543 elected members. It has primarily financial powers, and Rajya Sabha, it is called as upper house. So it is indirect election by the state legislatures. So maximum number of people are 250 and 238 as elected and 12 are nominated. So it is called as a permanent house with 1/3 members retires every 2 years, and it represented by the interest of the states. So the two houses complement each other, providing checks and balance legislature process. The Lok Sabha holds greater power in financial matters and conference vote, while Rajya Sabha ensure that the state representation. So let us discuss about the state legislature assembly council. So legislative assembly is also called as Vidhan Sabha, and legislative council this is also called as Vidhan Parishad. So in assembly, legislative assembly directly elected by the people every 5 years. Okay, the members ranging from minimum 60 to 500 people depending on the state population. So primary it's the duty of the legislature, the primary lawmaking body in the state level, and it elects the chief minister and holds the financial power. And it comes to the legislative council, that is Vidhan Parishad. It is a optional upper house. Only presently 6 states have this legislative council, that is Vidhan Parishad. So 1/3 of the assembly sees the size like it is 1/3 of the assembly size but not exceeding the one-third of total assembly members. So it is indirect election through various constituencies. So like graduate MLC, teacher MLC, like that. Then it has the limited powers and can delay but not black most bills. Also, it has the very less power compared with the legislative assembly. Then here, what is the powers and functions of legislature? So one is the law making power. So it introduced and debates, amending, passing the bills that become laws after the presidential or governor assent. Then it has the financial control. So it approves the budgets, imposing the tax, scrutinizing the government expenditure, and ensure that fiscal accountability. And one more power is the executive power. So in this, whether it is parliament, in assembly, the questioning by ministers, moving resolution, forming committees, then potentially removing the government through non-confidence motions, etc. Then if you consider the constitutional power, so amending the constitution, Indian parliament, it can be, the constitution can be amended. So participating in election of the president, vice president, and approving emergency declaration. And judicial function, so impeachment of the president, judges, and other officials, try to contempt cases against its members. So the functions are powers of the legislature: law-making power, financial control, executive control, constitutional powers, judicial functions. So then we'll discuss one of the important point, that is called anti-defection law. So the purpose and meaning. So anti-defection law introduced by the 52 amendment in 1985 to combat political defections and ensure that stability in government. It was further strengthened by the 91 amendment 2003. So under the 10th schedule of the constitution, member can be disqualified if they voluntarily give up their party membership, vote against party direction, that is a whip in the house, abstain from voting when directed by the party to vote. So we can see in the Telangana government what is happened. This is anti-defection law. Then exceptions and implementation. Exceptions are allowed in this particular anti-defection law. So a merger of 2/3 members of the party with other party occurs. So the original political party merges with another party. A person is elected as a speaker, chairman, can resign from the party. So the presiding officer here, speaker or chairman, decide the disqualification cases subject to the judicial review. So the final power lying with the speaker or chairman. In the state, it comes to as a speaker. In the, like in parliament also, speaker or chairman comes into picture. So executives in India in union level. So the president of India, prime minister, council of ministers. So president of India, constitutional head of state, elected indirectly for every 5 years term. So he acts and aid and advise to the council of ministers. So according to Article 74, and the president represents the unity of the nation. Then it comes to the prime minister. He is the real executive head appointed by the president, usually leader of the majority party in Lok Sabha, act as a link between president and council of ministers, guides overall policy. Then comes to the council of ministers. So there is a 3-tier structure is there: cabinet ministers, ministers of state, and deputy ministers. So they collectively responsible to the Lok Sabha. Maximum size limited to the 15% of the Lok Sabha, strengthened by the 91st Amendment. So the doctrine of collective responsibility ensure that ministers speak in one voice and stand or fall together. This is the executive in India, union level, President of India, Prime Minister, Council of Minister. Then we'll check about the governor and state executive. So we already discussed about the union government, and let us discuss about the governor and state executive. So governor is appointed by the president for 5 years term. Okay, then is the constitutional head of the state government. So he can serve multiple states simultaneously. So the qualification is what is the eligibility is that he should be a Indian citizen. He should have 35 years age or above. So not holding any office of profit. Okay. Then it comes to the chief minister and council. So chief minister is appointed by the governor. Usually he is a majority party leader. So he is a real executive authority at state level. So council of ministers helps and advise the governor. So collective responsible for the legislative assembly. So the landmark case of S.R. Bommai versus Union Government 1994 established the important guidelines for governor's power, particularly regarding dismissal of the state government and imposition of president rule. Then powers of president and governor. So it is almost similar. They have the powers of president and governor, executive powers, legislative powers, judicial powers, and emergency power. So executive powers are making high level appointments like judges, ambassadors, etc., and conducting administration, granting pardons, and representing the nation or the state. Okay, here I am discussing about the president as well as governor and legislative power. So summoning and dissolving the legislature, addressing them, sending messages, giving assent to bills, and issuing ordinance and during the recesses. And we'll discuss about the judicial power, whether it is governor or president, granting pardons, reprieves, respites, remissions of punishment to convicted person, and consulting Supreme Court on questions of the law and fact. Then whether it is government or president, the power of emergency power. President can declare national, state or financial emergency. Governor can report to president about the state constitutional failure. So while the president and governor exercise these powers, they generally act on the advices of the respective council of ministers, except in rare discretionary matters. So let us check one more. So here the laser point. Okay. Then judiciary role of a Supreme Court. So Supreme Court of India, it is a apex judicial body established under Article 124 of the Constitution. So currently Supreme Court consists of 34 judges, including the Chief Justice of India. Simply we can called as CJI. So key functions of the Supreme Court. So original jurisdiction. So it solves the disputes between governments, and appellate jurisdictions, that is appeal from the courts, advisory jurisdiction, presidential references. Then review jurisdiction, it reviews its own judgment, and writ jurisdiction, so protecting fundamental rights. So powers and functions of High Court. So we'll discuss about the what is the powers and functions of the High Court. So original jurisdiction, appellate jurisdiction, then writ jurisdiction. So original jurisdiction, so enforcement of fundamental rights, that is Article 226. Then election disputes of the state legislature and parliamentary members, revenue matters and admiralty cases, then supervision of subordinate courts. Then appellate jurisdiction, like civil and criminal appeals from district courts, appeals from tribunals, letters patent appeals, intra-court appeals, then reference appeals or questions of law. Then writs jurisdiction, habeas corpus, that is a personal liberty, mandamus, command to public authority, prohibition, prevent for lower court action, then centuary, transfer cases for review, quo warranto, challenges public office. So there are 25 high courts in India, in some with some having jurisdiction over multiple states and union territories. So they serve as the principal courts of original jurisdiction in their states. So let us discuss about the subordinate judiciary, its importance. Let us see the structure. The subordinate judiciary form the backbone of Indian. It is the backbone of Indian justice system. It is handling the vast majority cases. So here it is divided into district and session courts, municipal civil judge courts, then magistrate courts, then special courts. So like district and session courts, it is a principal civil and criminal courts at district level. Then municipal or civil judge courts, it is a lower civil courts. Then magistrate courts, lower criminal courts. Then special courts, it is for the specific matter like family, consumer, etc. Then let us discuss what is the significance of having the subordinate judiciaries. And okay, subordinate courts are crucial because they are provide the first point of access to justice to every citizen. So it handles the over more than 90% of all litigation in the country. So implement most civil and criminal laws directly, and it is reduce the burden on higher judiciary like High Court and Supreme Court. So it ensures that justice reaches to the grassroots level. So the quality of and efficiency of the subordinate courts directly impact on the public perception of the judicial system and access to justice. Then independence of judiciary. So in the appointment process of the judges of Supreme Court, judges of High Court appointed by through collegium system, that is evolved through these three judge cases, like president appoint in consultant with the judiciary. Okay, then limiting executive influence. Then let us what is the security of this judicial system. So the tenure is secure. Judges can only removed through the impeachment proven misbehavior or capacity. So in order to remove the judges, it requires special majority in parliament, and to removing the judges is very difficult. Then financial security. Then salaries and allowance charged on consolidated fund of the state or the India. So cannot be varied disadvantage during the term. Post-retirement benefits also secure for the judges. Then administrative autonomy. So courts are control their own administration, staff appointments and procedural rules. Chief Justice is the administrative and head with the significant powers. So judicial independence ensure that court can function without fear or favor. So upholding constitutional values and protecting citizens' rights against government excesses. Then judicial accountability. So need for accountability, what is the existing mechanism, we'll discuss. While independent is crucial, accountability ensure that judiciary remains trustworthy. So like it prevents the misuse of judicial power, ensure that ethical conduct by judges, maintain the public confidence in judiciary, improve the efficiency and quality of justice. So, what is the existing mechanism to ensure that judicial accountability? So, current accountability measures includes in-house procedure, impeachment, contempt powers, judicial standards, public scrutiny. So current accountability measures includes like in-house procedure. So it investigates by the complaints, and impeachment for the proven misbehavior, contempt power, so balance with the criticism rights, and judicial standards adopted by the judiciary, public scrutiny through RTI. It is very limited. So the challenge remains in balance the independence with accountability without compromising either. So various proposals including National Judicial Commission have the debate but not implemented. So let us discuss about the what is the state and central relationship. So what the relation between the central government and the state government relations. So it is broadly categorized into three ways. One is the legislative relationship, then administrative relations, and financial relationship. So legislative relations means distributing the lawmaking power through the union. State and concurrent list, it is mentioned in the 7th schedule, article 245 to 255. Administrative relationship, so division of executive function and mutual obligation between union and state, that is article 256 and 263. Financial relationship, so allocation of the taxation powers and revenue distribution via finance commission, article 268 to 293. So India follows the cooperative federalism, where center and state works together while maintaining their autonomy. So however, the constitution title powers towards the center in emergency. So earning the system description of federal in form but the unitaries in spirit. So the key mechanism like GST Council and Niti Aayog now promotes the cooperative policy making the between policy making between state and center. So let us discuss local self-government. So by the 73rd Amendment 1992, Panchayat Raj institutions like there is a three-tier system: village, block, and district. Okay, direct election in all level, that is in village, block, and district, and reserve seats for the SC, ST, and women. Nowadays, 33% for the women. It is a fixed term for 5 years. So the elections is conducted by the State Election Commission. So the State Finance Commission reviews the finance, and by the 74th Amendment 1992, urban local bodies, municipal corporation, municipalities, nagar panchayats. So the this is a direct election with the reservation similar to the Panchayat Raj institutions, that is the PRIS. Then ward committees for the population over 3 lakhs. So district planning committee for integrated development. Then metropolitan planning committee for metro areas. So these amendments added part 9 and part 9A to the constitution, making the local self-government a constitutional obligation rather than just directive principle. So we'll discuss about the state liability in torts and contracts. So historical background: in British India, the doctrine of sovereign immunity protected the state from liability. Post independence, article 300 established the state liability equivalent of the Dominion of India and princely state. Then contractual liability. So government is bound by the contracts made in exercise of its executive power. There is Article 299. Contract must be executed by the authorized person uh, in prescribed manner to be enforceable against the state. Then tortoise liability. The Kasturi Lal case in 1965 initially upheld the sovereign immunity for state actions. Later judgments like Rudal Shah and Nilabati Bahera established state liability for fundamental rights violation. So modern trend is towards the increasing the state accountability, with the courts frequently awarding compensation for state negligence, particularly in case of custodial violence, illegal detention, and human rights violations. So emergencies in the constitution. So national emergency, there is article 352, then state emergency article 356, then financial emergency article 360. So national emergency article 352 declares the state during war, external aggression, or armed rebellion. So it requires cabinet recommendations, writings, then must be approved by the parliament within 1 month, can be extended indefinitely, approval with approval for 6 months. So fundamental rights under article 19 automatically suspended. Then state emergency, it is article 356 mentioned, imposed by if the state government cannot function as per the constitution. So known as the president's rule, initially valid for 6 months and extended up to, it can be extended up to 3 years. So state assembly dissolved or suspended and restricted by the S.R. Bommai judgment 1994. Then it comes to the financial emergency article 360, declared in financial stability or credit of Indian threatened. So never this particular financial emergency as per never imposed in India. So it allows the center to give financial direction to the states, can reduce the salaries of the government employees including the judges. It requires parliamentary approval within 2 months. So emergency provisions have been amended significantly by 44th Amendment 1978 to prevent misuse after 1975-77 emergency experiences. So do like Mohan's teaching corner and subscribe, share with your friends. Thank you for listening this class. All the best for your coming examination.